Exam Scholar, Real Estate Edition.
Question 1. The following could be used by the buyer as earnest money deposit in purchasing real property. A. A promissory note secured by a deed of trust. B. A post-dated check. C. An unsecured promissory note. D. All of the above. Answer: D. This deposit can be in any form but must be disclosed to the seller prior to the seller accepting the offer. Question 2. All of the following are required of a real property security dealer, except A. A real estate broker's license. B. The issuance of a real property security dealer's statement to each person purchasing a real property security. C. File and maintain with the Commission a $5,000 bond. D. Post an additional $5,000 bond for each series transactions involving a real property security. Answer: C. Only one bond is required. An additional permit is required for each series of transactions. Question 3. Seller Abel, the owner of Blackacre, lists the property for sale with broker Baker. Abel fails to authorize the agent to accept the deposit on his behalf. Buyer Charlie makes an offer on Blackacre and gives broker Baker a check for $5,000 as a deposit. Under these circumstances, broker Baker A. Can accept the check if he immediately gives it to seller Abel. B. Can accept the deposit an agent for the buyer Charlie and place the monies in the broker's trust fund. C. Cannot accept the deposit because of the wording of the listing agreement. D. None of the above. Answer: B. The owner did not authorize the broker to accept a deposit on his behalf. The law of agency demands an agent to accept all offers unless specifically instructed by his principal not to do so. Under these circumstances, the broker should take the offer. However, he would accept the deposit at the agent of the offeror, and hold the deposit as the agent of the buyer. Question 4. Which of the following is real property? A. Stock in a mutual water company. B. Fruit on trees already sold by contract. C. Minerals or gas removed from the ground. D. Crops before harvest. Answer: Stock in a mutual water company is an appurtenance. Each share is considered to be appurtenant to a specific piece of real property and cannot be sold separately. An appurtenance is defined as real property. Question 5. Using a note as a deposit from a buyer in making an offer. A. The note must be cashed before opening escrow. B. A note cannot be used as a deposit for an offer. C. The note would be the same as cash. D. The agent should inform the seller that the deposit is in the form of a note before the seller accepts the offer. Answer: D. A licensee may accept a note from a buyer as a deposit, other in the form of a deposit given by builders. The licensee must then inform the seller that the deposit is a note before the seller accepts the offer. Question 6. Richard Rock, a new real estate salesperson, made strong efforts to obtain listings in an unintegrated community. He found success by insinuating to property owners that should minorities move into the area, the value of their homes would increase. Which of the following terms best describes the activities of salesperson Rock? A. Steering. B. Panic peddling. C. Blockbusting. D. Both 1 and 3. Answer: D. Such activity is described as both panic peddling and blockbusting. Question 7. Which of the following will be found in the Federal Fair Housing Law? A. A provision that real estate licensees should not discriminate in the sale of any real estate. B. A code of ethics which requires all real estate brokers to follow the Golden Rule. C. A provision which allows for mortgage subsidy insurance in government loans. D. A provision which allows all prospective buyers to be given the same opportunity to select available houses in their price range without restrictions because of race, color, religion, or national origin. Answer: D. The Federal Fair Housing Law applies to residential property and prohibits discrimination on the basis of color, race, religion, or national origin. Question 8. A real estate broker advertises that if a buyer buys from him or a seller lists with him, he will pay the party $50 from the fee or commission he receives from the transaction. The broker A. Can do this. B. Cannot do this as it is a violation of the Business and Professional Code number 10176. C. Can credit the buyer's escrow account with $50 but he could not compensate the seller. D. Can give a rebate of commission to the seller, but he cannot pay the $50 to the buyer. Answer: A. This constitutes a finder's fee which may be paid to unlicensed person as long as the fee remains a finder's fee. A finder's fee is payable when the person has no negotiations in the transaction whatsoever, he just tells you of the prospect. You need a real estate license if you act as an agent. There is no license required to act as a finder. A finder does not represent anyone, they merely tell a licensed agent about prospects. He does not enter into the negotiations. Question 9. The law which governs the distribution of property after a dissolution of marriage is contained in the A. Code of Civil Procedure. B. Civil Code. C. Business and Professions Code. D. Commissioner's Rules and Regulations. Answer: B. The law which governs the distribution of property after a dissolution of marriage is contained in the Civil Code. Question 10. The distinguishing characteristic of a real estate option when compared to a conventional contract of sale is its A. Lack of mutuality and obligation. B. Irrevocability. C. Mutuality of contract. D. Both 1 and 2. Answer: A. Only one party is bound by the contract in a real estate option. The optionee has the right to either purchase or not purchase.
Passing the real estate exam can be hard, like really hard. Statistically, only about 50% of people actually pass the real estate exam on their first try. Those people that pass, they go on to become real estate agents. And the people that didn't pass, they either give up completely or have to try again. Both of these options are painful, disappointing, and upsetting. Exam Scholar Real Estate Edition has been named as the best real estate exam prep by multiple publications for 7 years in a row. If you are about to take the real estate exam, Exam Scholar Real Estate Edition is a no-brainer choice. There is no other real estate exam preparation service out there that comes close. To enjoy the longest membership time, lowest cost, real estate videos, audios, articles, flashcards, vocabulary, exam tips and tricks, a 1-year no questions asked refund policy, and be one of the 35,000 people that it has helped pass the real estate exam, then sign up in less than 5 minutes at www.realestateexamscholar.com.
Question 1. If an asset is showing a decline in monetary value or a decline in the value of property, this is best known as A. Depreciation. B. Expense. C. Declining value. D. Comparable dispersion. Answer: A. Depreciation is a decline in the value of property and, in accounting, is the declining value of an asset. Question 2. In the most basic sense, debt is considered A. Any amount owed to another. B. A credit from one person to another. C. An owed amount with interest. D. Anything of value that is borrowed from another. Answer: A. An amount that is owed to another is probably the simplest form of the definition of debt. Question 3. A loan in which the lender makes payments to the builder at periodic intervals as the work progresses is best called A. A short-term interim loan. B. A construction term loan. C. A convertible construction loan. D. A periodic convertible loan. Answer. A. A short-term interim loan is a loan in which a lender makes payments to the builder at periodic intervals as the work progresses. This type of loan is also known as a construction loan, but not called a construction term loan. Question 4. Homeowners association fees are also sometimes called A. Common area assessments. B. Condominium fees. C. Common designated conveyances. D. Area commune fees. Answer. A. Homeowners association fees are also sometimes called common area assessments. They are paid by the individual owners and are used to maintain the property or common areas. Question 5. A time deposit that is held in a bank that pays a certain predetermined amount of interest to the depositor is known as A. A certified deposit. B. A certificate of deposit. C. An interest-bearing account. D. A time-stamped deposit. Answer. B. A time deposit that is held in a bank that pays a certain predetermined amount of interest to the original depositor is called a certificate of deposit. Question 6. If a homeowner refinances the mortgage on the property at a higher amount than the current loan balance for personal use, this is called A. Cash out refinance. B. Reverse mortgage. C. Equity line of cash. D. None of these. Answer. A. A cash out refinance is when a homeowner refinances the mortgage on the property at a higher amount than the current loan. This happens when the current borrower intends to use the money for personal use. Question 7. The final lump sum payment due at the termination of a specific type of mortgage is best called A. A hovering payment. B. A balloon payment. C. A floating payment. D. A deferred payment. Answer. B. A balloon payment is a lump sum payment that is due at the termination of a balloon mortgage. Question 8. The best definition of an appraiser is A. An individual qualified by education and experience to estimate the value of real and personal property. B. An individual that works for lenders exclusively to estimate the value of real and personal property. C. An individual that works exclusively independently as a contracted agent to estimate the value of real and personal property. D. None of these. Answer. A. An appraiser can work for lenders or they can work as independent entities. They are always qualified by education and experience to determine the value of real and personal property. Question 9. A value created according to a government formula intended to reflect the true annual cost of borrowing expressed as a percentage is called A. PR. B. ARP. C. CPR. D. ADR. Answer. A. Annual percentage rate, otherwise known as APR, is a value created according to a government formula intended to reflect the true annual cost of borrowing expressed as a percentage. Question 10. Liabilities, including long-term and short-term debt and any amounts owed to others, is best known as a person's A. Financial obligations. B. Net worth minus expenses. C. Debt. D. Assets. Answer. A. A person's liabilities that include long-term and short-term debt as well as amounts owed to others is best called their financial obligations. Question 1. Land is typically appraised by what approach? A. Income approach. B. Gross rent multiplier approach. C. Option approach. D. Market data approach. Answer. D. Land is typically appraised by the market data approach by comparing the subject property to recent sales data of comparable parcels of land. Question 2. If Sarah Jean recently begins to receive her own tax bill after purchasing her property, this means she has most likely purchased into A. A condominium. B. A lease. C. A tenancy in common. D. A syndicate. Answer. A. A condominium is owned in fee simple, just as a normal home would be. This means that the homeowner, or condo owner, receives his or her own property tax bill. Question 3. Which party is most likely to sue for specific performance in regard to the purchase of real estate? A. The buyer. B. The seller. C. The broker. D. The attorney of the brokerage. Answer. A. The party most likely to sue for specific performance would be the buyer. This is done by the buyer to force the seller to sell. Question 4. When are mils most often used? A. In the calculation of square inches. B. In the appraisal of the property. C. In the assessment of the county fire code. D. In the assessment of property taxes. Answer. D. Mils, each 1/10 of a cent, are sometimes used to express the tax rate per dollar of assessed value. Question 5. What is the difference between market value of a property and the debt on the property including all liens? A. Income ratio. B. Assessed value. C. Equity. D. Market fluctuated value. Answer. C. Equity is the difference between the market value and the debt on the property. Question 6. The first step of a jurisdiction attempting to enact eminent domain is to A. Attempt to purchase the property in question. B. Give the owners a 30-day notice to vacate. C. Seek an injunction. D. Obtain a writ of closure. Answer. A. The first step of the jurisdiction would be to attempt to purchase the property at a fair market rate. Question 7. If the buyer, Sue, gives her agent, Jesse, an envelope of cash to hold as her earnest money for the property she wishes to buy, she is trusting that Jesse will protect this money for her and is an example of the fiduciary duty of A. Due process. B. Accounting. C. Competence. D. Escrow. Answer. B. This is the fiduciary duty of accounting. The agent must be able to hold and produce anything that is given to their care. Question 8. If a contract has a clause that states time is of the essence and either party fails to act in a timely manner to execute the contract, they can be held in A. Breach. B. Default. C. Void. D. Non-performance. Answer. B. If any party fails to take care of their matters in a timely manner in this situation could be held in default of contract. Question 9. In an area neighborhood that has a home in a dilapidated state that would require extensive remodeling to be compared to other homes in the area, what would this be an example of? A. Depreciation. B. Incurable depreciation. C. Curable depreciation. D. None of these. Answer. B. This is an external factor caused by the other homes in the area. This is a form of incurable depreciation. Question 10. The civil penalty for a first violation of the federal fair housing laws can be as much as A. $1,000. B. $5,000. C. $10,000. D. $50,000. Answer. D. The court may assess civil penalties against the violator up to $50,000 for a first violation and up to $100,000 for any subsequent violation. Question 1. During broker Shaw's preparation of the exclusive authorization and right to sell on seller Norman's property, Norman asked that a clause be included which would require the buyer to accept primary liability in connection with when the existing loan is transferred to the buyer. Shaw should enter which of the following in paragraph 2 of the exclusive authorization and right to sell? A. Buyer to take the property subject to the loan. B. Buyer to assume existing loan. C. Buyer to pay all cash. D. Buyer to make a large down payment to preclude possibility of a foreclosure. Answer. B. If a buyer assumes an existing loan, he accepts primary liability for that loan. Question 2. A third party who takes a promissory note that is complete and regular and has no knowledge of any defects is known as A. An endorser. B. A maker. C. A payee. D. Holder in due course. Answer. D. The party that accepts the endorsed note from the original payee without knowledge of any defects is known as the holder in due course. Question 3. The owner of a single-family residence plans to sell and wants to obtain an FHA appraisal to permit a sale with FHA financing. He should A. Contact the nearest FHA office for an appraisal of this property. B. Have a lender apply for a firm commitment. C. Have a lender apply for a conditional commitment. D. Submit a recent appraisal of his home to FHA. Answer. C. The recommended process for the lender to contact FHA for a conditional commitment, that is, for advance assurance that an FHA loan will be made, establishing the loan value for the house. Question 4. A buyer defaults in making payments on a loan, therefore the lender's action probably would result in A. Subordination. B. Escalation. C. Acceleration. D. Alienation. Answer. C. Acceleration indicates the right to declare the entire sum of a note to be due and payable immediately. Most trust deeds contain several acceleration clauses. Most common states, if you become delinquent in the payment on this note, the entire sum of the note becomes due and payable immediately. Other states, the entire sum of the note is due upon the sale or transfer of the property triggered by the sale of the property and therefore is a specific acceleration clause. The rule is, alienation clauses are types of acceleration clauses, but not all acceleration clauses are alienation clauses. Question 5. Which of the following is the classic definition of the boundaries of real property? A. A surface area indicated on a map. B. A reasonable use of airspace and extended to the center or the earth. C. A reasonable distance down and unlimited airspace. D. A practical or reasonable use of the earth and unlimited airspace. Answer. B. The surface of the earth and the material beneath the surface to the center of the earth is part of the real property. Since airways are now public domain, the ownership of airspace is used to an enjoyable and reasonable height. Question 6. A buyer defaults on a loan, therefore the lender would be able to cause the promissory note to become due and payable. This clause is A. A subordination clause. B. An escalator clause. C. An acceleration clause. D. An alienation clause. Answer: C. Acceleration clauses are several different types and reasons. Question 7. In general, when the supply of a certain commodity increases, A. Price tends to rise. B. Price tends to drop. C. Demand for it tends to rise. D. Demand for it tends to drop. Answer: B. If demand is constant and supply increases, sellers compete with each other by lowering prices. Question 8. An offer to purchase real property was signed by a prospective buyer on October 2, 1977. The terms of the offer allowed 5 days for acceptance by the seller. Because of an illness in the seller's family, the seller did not accept the offer until October 10, 1977. Which of the following statements is correct? A. The buyer may demand the return of his deposit. B. The buyer must continue with the purchase because he did not withdraw his offer prior to acceptance. C. If the buyer does not complete the purchase, the seller is entitled to the deposit. D. If the buyer does not complete the purchase, the seller and the broker will each be entitled to 1/2 of the deposit. Answer: A. This constitutes only an offer, and one method of terminating an offer is the expiration of a specified or reasonable length of time for the acceptance to be communicated. Question 9. An offer by one of the parties to a real estate transaction to carry out that party's part of the contract is called A. Gratuity. B. Satisfaction. C. Recourse. D. Tender. Answer: D. Usually made at the conclusion of the transaction, the tender is the offer to perform on the terms agreed to. If the other party cannot perform, then the party that made the tender can rightfully claim the other party defaulted. Question 10. Should a person be discriminated against, what would best describe the actions available to them? A. Private action in a state or federal court. B. Civil action in state superior court. C. Criminal action in a state court. D. Criminal action in a federal court. Answer: A. As discrimination is not a criminal act, we would eliminate answers 3 and 4. 2 is incorrect, as the remedy available to the injured party is not limited to only action through a state court. It could take place through the federal courts. Question 1. A real estate broker only has a right to earn a commission when the property sells during the listing period, except when which of the following is included in the listing agreement? A. A broker's protection clause. B. Exculpatory clause. C. A subordination clause. D. None of the above. Answer: A. The broker is entitled to a commission if the property is sold to parties with whom he has negotiated during the term of the listing for a stated number of days after the listing expires. Question 2. Harris and Davis, single people, owned a parcel of real property as joint tenants. Harris encumbered his interest for $10,000, borrowing the amount to pay medical bills without the knowledge or consent of Davis. Shortly thereafter, Harris died, with the debt still unpaid. Which of the following would be true? A. Davis and the lender would be tenants in common, each owning 1/2 interest in the property. B. Davis would own all of the property free and clear of the encumbrance. C. Davis would own all of the property but would be subject to the $10,000 loan. D. Davis and the beneficiary would own the property as joint tenants, each with a 1/2 interest. Answer: B. On the death of one joint tenant, The survivors take title to the property without the obligation to pay on foreclosed liens. Question 3. Occasionally, the title to real property becomes unmarketable. Which of the following causes would be least likely to result in that eventuality? A. Imperfect title, due to a breach caused by adverse possession of a prior owner. B. A lease pendens filed by the husband of the owner of record. C. Restrictions imposed by a private owner through a deed notation. D. Public restrictions contained in zoning ordinances and building codes. Answer. D. Public restrictions rarely cause title to real property to be unmarketable, private restrictions sometimes do. Question 4. Prices have risen 20%. What has happened to the value of the dollar? A. It has gone down 16 2/3%. B. It has gone down 20%. C. It has gone down 25%. D. None of the above. Answer. A. For instance, an item that used to sell for $1 now sells for $1.20. The dollar now buys 5/6 of what it used to buy. Its value has gone down 1/6 or 16 2/3. Question 5. What supports the floor and ceiling loads? A. Joists. B. Studs. C. Supporters. D. Mudsills. Answer. A. Joists are the beams that run horizontal and parallel to each other and are used to support the floor and ceiling loads. Joists are beams, not rafters. Question 6. A broker who takes a listing with option to purchase is, first of all, A. A principal. B. An optioner. C. An optionee. D. An agent. Answer. D. A listing agreement which contains an option to purchase is first of all a contract employing the broker to act as an agent for the owner in the sale of the property, and that is his principal role. If he exercises the option, he operates in the capacity of a principal in its resale, but this is secondary to this responsibility as an agent. Question 7. An inner-city neighborhood is well integrated with civic groups working to maintain social harmony. However, mounting problems with schools and with increasing crime have caused several white families to move out. In which of the following statements is broker Brown in violation of the law? 1. He is actively soliciting listings in the area with the slogan "Sell Now, Save Equity." 2. He is offering lower commission rates to whites who patronize his business. A. 1 only. B. 2 only. C. Both statements. D. Neither statements. Answer. C. Both of these acts are in violation of the fair housing laws. Question 8. The liquidation of a financial obligation on an installment plan or basis is A. Conversion. B. Amortization. C. Acceleration. D. Conveyancing. Answer. B. Amortization means to pay principal and interest over the life of the loan. Question 9. Mr. and Mrs. Davis held real property as husband and wife. Mr. Davis died and his will specified that all his interests were to go to his eldest son, Thomas. Son Thomas would A. Inherit an undivided 1/2 interest in the property. B. Acquire a 1/2 interest in the property. C. Acquire title to the property in fee simple, as he is the eldest male heir. D. Acquire no interest in the property as it would automatically go to the widow. Answer. A. Under the community property law, either spouse may will his or her undivided 1/2 to anyone they choose. Question 10. Inasmuch as real property requires more time to market than listed securities, require more care, and comes in larger denominations, its return should be A. About the same as from bonds. B. Higher than from bonds and less than from first trust deeds. C. Equal to the return from first mortgages. D. Higher than that of bonds or first mortgages. Answer. D. The return from real property should be higher than from bonds or first trust deeds because of the above factors.
Exam Scholar, Real Estate Edition.